What's up, all you dads out there? We're going to get this started. I do want to see if some people are going to join the stream, giving some people some time to get in. In the meantime, I'm going to work on just getting some things set up here with the stream so that everybody can talk and I can get all the chat information and stuff like that going. I can't do any of that stuff before I uh, go live. It requires me to pop those screens out after I go live. So that's what I'm going to do right now while we're waiting for some people to join the stuff. You're not going to want to miss this. I'm going to start sharing some information and I'm going to give you guys some scheduling as to when you can come back and check these posts out for more information. If you're going through a court battle right now with your ex or and you have some kids and you're starting custody issues and starting to go down that road, or maybe you're just trying to get a little extra information on that stuff. That's the kind of stuff that I'm going to be covering tonight. That's the stuff that we're going to be starting to go over. So stick around. You definitely don't want to miss this stuff. One more here. Okay, y'all. So we're going to go ahead and get started here, and we're going to start making some things happen. All right, Dad. So a little bit about me. I have spent 20 years of my life as a freelance paralegal, among other things. That has been a real strong hobby of mine for the most part. I really enjoy looking at the law and researching the law and reading the law and stuff like that. So um, it's something that I've enjoyed doing. The piece of it that I have not enjoyed doing is the family court aspect of things. That has been an absolute bear of a challenge, and I know that when it comes to family court and the way everything turns out, I'm really in the minority when it comes to other dads out there. Both of my kids live with me full time. I have a 15-year-old and a 9-year-old. And unfortunately, some really bad things happened for us to get to a point where the kids are with me all the time. That's the real challenge to everything, and that's the part that really hurts my heart. Um, I got an echo here, so so what I'm trying to do here is I'm trying to spread some awareness. I'm trying to lead by example and going to start taking the knowledge that I do have in paralegal skills and start pushing that out towards all of you dads. So I'm going to spend probably about an hour tonight, maybe a little less, maybe a little bit more, depends on how hot this stream gets. If you're watching this and you see it and you want to take part in it, then please, I've got all of my chat windows open right now, and I'm looking for questions directly that affect you and what you're experiencing and what you're going through right now. So um, the other things that I do is I do also stream some of my games and stuff like that. That's what I do as a dad in my spare time, what I do in my free time, and kind of what I do to decompress. So I just share that stuff because again, it's fun. I just enjoy hanging out with people and doing what I need to do. So, but playing games is just a de-stressor for me, and you can catch some of that live stuff too when I post those things. I'm looking to probably be going live with this legal stuff at least a couple of times a week. There's a lot to the legal system, especially when it comes to family court, and I know that there's a lot of dads out there that really, really need help. So I'm really leaning into the dad community. I learned about dad supporting dads and dude supporting dudes, a movement going on the social media platforms where they are essentially sharing each other's posts and sharing each other's pages and stuff like that to get some recognition and kind of push the algorithms in the favor of dads so we can get some of the information out there and so that dads don't feel completely all alone and completely deflated and defeated in any of the processes. So dad supporting dads, dude supporting dudes, thanks for giving me the influence today to start this stuff, and we're going to start going strong with it, and we're going to start really pushing this stuff out. So, one of the big tools that I do use in all of this stuff, and this is what's up on my screen right now, is ChatGPT. Couple warnings about ChatGPT or any AI for that matter. There are some AIs out there. There's tons of AIs out there. The big thing that you need to be concerned about with AI is accuracy. You need to be checking AI to make sure that it's accurate. If you mess up when it comes to court, whether it's filing a motion in court, filing your petition for divorce, stuff like that, you need to know what you're doing and you need to know how all that stuff is going to happen and how it's all going to work. If you don't know how to do that, then you're really starting off on a bad foot and you're really going to go in unprepared and you're going to have a real hard time defending yourself or even putting the other side on the defense. So, ChatGPT is a good place where I start. This is where I come to and I say, okay, I got some questions, I got some things that I've got to get off my chest, and we're going to start talking about them. So, for instance, today what I wanted to go through and what I wanted to start talking about is the divorce process and how to start it. How to start it all. Now, I am in Florida. My IP address is here in Florida, so ChatGPT has stolen all of my information, and they know that I am here in Florida. So I haven't tested this AI lawyer stuff yet. I do plan on digging into this a little bit and seeing how accurate it is and how much it can help us. So I'll have another session on that in the coming days or in the coming sessions and in our coming live sessions. So stay tuned for that and let's get this stuff done. Um, so let's go. How to start a step-by-step process. So what I did is I came into ChatGPT and I was like, hey, give me a general rundown of how to start a divorce proceeding in court, step by step, getting it filed, where I need to find the important information. And it gives me its generic reply, and then it starts to list everything out. So um, one of the first things that it came up with, and I can verify 100% that this is true, is determining where to file. Jurisdiction is absolutely crucial. There's a lot of things that go into a court filing. Jurisdiction just happens to be one of them. And jurisdiction essentially means that the court has the authority to make decisions in your case. And that comes down to your residency and what state you and your ex-spouse or ex-girlfriend, depending on if it's a parentage case or a divorce case, depending on what that is. So let's quickly run down what the difference is between divorce and a parentage case. Divorce is in a situation where the couple was married and they have a actual marriage license and they went through the whole formal process of solidifying that marriage contract within the state that they live in. So that's a marriage that once you establish a marriage that is 100% legally binding, and there are some things that come with that like property division, marital assets, stuff like that. It's all things that are going to be talked about when you're filing for a divorce. Most of those things are going to get split down the middle, and both parties are going to take a percentage of responsibility for whatever debt or assets or whatever you have out there. A court judge is essentially going to decide how that stuff gets split up. A lot of things go into that stuff, so those kinds of things that do go into it are kind of like most states nowadays have adopted what's called a no fault rule, no fault divorce, which just basically means you can get divorced for any reason you want. You don't have to have a divorce reason. You don't have to have any adultery happening in there. There does not have to be abuse. There does not have to be anything in that stuff that puts one or the other person at fault. Essentially, you may have heard um, of people just going in there and claiming that there's irreconcilable differences, which just basically means that there's problems in the marriage that the couple can't fix, and they believe that they've reached the end of their ropes, and at the end of the ropes, it's just irreconcilable. We can't do this. We can't fix it, and we want a divorce. So that is legal. That is a legal definition to get a divorce, and it essentially means that anybody, one side or the other, both sides don't have to agree. One side or the other can petition for a divorce, and a divorce can be granted on those grounds that we just can't fix this. Adultery and stuff like that doesn't come into this as much anymore. It can help lean a judge a little bit in favor of how they're going to split up assets and how they're going to split up the bills and stuff like that you might have as a married couple, depending on the actions of the other person. But ultimately, why you guys are getting a divorce plays absolutely no part in how everything gets laid out on the table, especially when it comes to custody matters. The big things in custody matters that are going to really take place and really take hold and stuff is going to be evidence of abuse. So if there is any sort of evidence of abuse, then those kinds of things are going to affect who gets custody, where the kids are safe, what the best interests of the kids are, and stuff like that. And you'll hear me say probably a lot during the stream that best interest is a big factor in stuff. I'm not going to go specifically through best interest factors because one, they do vary from state to state, and two, it's a really big topic and it's a really big thing, so it'll be set for a different uh, a different video that we do, a different live session that we do, and something that else that we'll talk about. So just going to say welcome to the people out there watching right now. If you enjoy this and you have other people that are in the legal process and they're going through a legal custody dispute, or they're going through a divorce, or they're going through a parentage suit, please go ahead and like and share this stuff. Let's get them involved in this. Let's get them some information as well. 20 years as a paralegal. Much of that time spent in the family court arguing my own cases pro se. I did hire a attorney for one of my motions that I filed, and that was just to get the experience of an attorney, not necessarily for them to lead the boat, but for them to teach me what I needed to know should I ever need to go to a trial again, and if I ever needed to find myself in the courtroom again, I didn't have to go out and spend those thousands of dollars on an attorney to do it. So she really got me going. She really got me knowledgeable in the court process and how to handle myself with the courtroom decorum. So, all right, back to determining where to file. Jurisdiction, you need to file in the state and the county where you and your spouse met residency requirements. In most states, just like you see up here as the Florida example, most states you have to live in one of the spouses needs to have lived in the state that they're filing in for 6 months prior to. Now that comes with a caveat too. Say one of your one spouse lives in Florida, we'll say, that's the example up on the screen, and we'll say another person lives in New York, okay? You can file in either one of the states, but there's going to be one state that's going to have what's called subject matter jurisdiction, and they're going to have more authority than the other state to be able to take care of things and handle things. So when it comes to splitting assets and stuff like that, it's going to be where those assets are and where where all the evidence of that stuff lies. So if you both moved out of a state that holds all of that evidence, then it's going to be one or the other states that you've lived in for at least 6 months. If one of you remains in the state that you both lived in and all of that evidence for a court is going to preside mostly in that state, then it's going to be best for you to file in that state that spouse still lives in and where all that evidence lies. So again, where you must file is going to be in the state and the county where you and your spouse met residency requirements. Usually for most states, it's for 6 months that you had to have been living in that state. How do we find that stuff? Very, very simple. Go into Google, type in your county name with family court divorce filing, and it should pop up with your county court name, and usually the family court district webpage that you're in will also show up in that Google search. So you're gonna go in there, you're gonna check that stuff out. As you can see, it's got again my state's judiciary website, and in there it's gonna have all sorts of different information, not just in that page, not just about family court. It's gonna be all of the courts. So I'm gonna have to dig down a little bit, and I'm gonna have to find out what I'm looking for in that stuff. So now when we're getting into the divorce stuff and we've figured out where we need to file and what county court we're going to be filing and stuff like that, we need to start getting our forms together and start getting the things together that we actually need to file for in that court. So what those things are, what things you're looking for, is first and foremost, you're looking for a petition of dissolution or a petition of divorce or a petition of separation, depending on what situation you're looking at. If it's a divorce situation, if it's a situation where you're not married, but you have a custody issue or a custody dispute that you need to be working out, you're going to be looking to establish parentage. And once you establish parentage, which is finding out who the father is, in the situation, usually by a DNA test, that can sometimes be established at the birth of the child when you both are in the hospital. They will usually give both parents a form to fill out and sign, and that will establish dad as a parent and getting dad on the birth certificate, etc. So if you're looking for a parentage case, then you're going to be filing a petition in a court for parentage to establish parentage, and that's going to either spawn off the process of establishing parentage, getting that DNA test, getting that DNA swab from the child, getting the DNA swab from the dad, sending that stuff out to the lab to be determined. And once that stuff comes back, if you are determined to be the father, then that's going to start off the legal proceedings within your jurisdiction of parental rights and parental responsibilities and things of that nature. So petition for divorce. It's usually assumed if the parents were of the child were married at the time of the birth of the child, that child is the child of both of the parents. So dad is easily put on the birth certificate in that situation. There's not usually too much of a question, and it's usually established process in court. And unless a dad challenges DNA, then you're going to be assumed to be the dad. So we're filing for a petition for dissolution of divorce of a marriage. To start a divorce, and we're filing to establish parentage and a petition to establish parentage if you are a non-married couple and you're looking to establish dad as the dad in the situation. The very next thing that you need to do is you need to get involved, get a summons filled out. This is going to be an important paper, and this needs to come along with everything else that you filed in court on that day that you filed that petition. So you need to include that petition for dissolution or that petition for establishing parentage with your summons. This summons is going to go to either a process server that's licensed in your area or your county, or some states require that it be served by law enforcement, so county sheriffs or any law enforcement jurisdiction or office that does serve process of service is going to, or service of process is going to be able to help you out in that stuff. These things all cost money, so, and I'll get to a little bit of that stuff in just a bit, but you're going to have to pay for that summons to be served and for the paperwork to be served with them. Now that summons is notifying your spouse or the other party, mom in a particular case, if you're filing for that parentage stuff. It's going to notify them, and it's going to give them a deadline to respond to. You're going to need to file a family law financial affidavit. That's going to disclose all of your income, all of your assets, and all of your debts. That's going to be an affidavit that you fill out for yourself to put on paper what you feel and what you see and what you have documentation of for all of your income that you personally have coming in, not the other party, for you personally coming in. All of the assets that you have, whether those are shared or divided, those all need to be put onto the affidavit, and any debts that you guys have, whether they're shared or individual, they're both going to need to go on there. So notice the social security number. This is required for identification of the parties, and it's not necessarily required to file and stuff like that, and it doesn't generally become public knowledge, so you don't have to worry about that either. Parenting plan. This is not necessarily something you're going to file right from the beginning. Some courts require it. Some courts do want to see what a parent wants to do, and they do require that stuff right in the beginning, but it's not necessarily mandatory. It's not necessarily something that you have to file at that particular moment. Parenting plan can come down the road a little bit when you're a little bit further along in the process or getting closer to a settlement, or maybe you're going through some mediation and you want to send a parenting plan to the mediator. This is just your idea of what you feel is going to be best in the situation, and it's going to outline what the custody is going to be, time sharing, who's going to help make legal rights, and how that are legal decisions and stuff like that, and how all that stuff plays out. So here's a tricky one. The UCCJEA is the uniform rules for jurisdiction of child custody cases that's adopted by all 50 states. Every state in the union has signed on to this stuff in one way or another, whether it was just the old way or they may have updated and joined on to the new way. There's two different things, but what it does is it helps establish what the home state of the child is. So, like I gave you that incident in the beginning where I live in Florida and maybe I have a spouse or a soon-to-be ex-spouse that lives up in New York. They're going to want to know where the kids have lived for the previous 6 months as their home state. But they're also going to some courts are going to ask for where the kids have lived for the last 5 years to help make sure that they have jurisdiction over making those custody decisions and stuff like that. So if you have moved around and stuff like that a few times, and that's a question, then those are questions that we need to be seeing here pop up in live chat, so we can do real time research to figure out how that process works for you. And I want to work with dads across the country, across the world, to help you guys figure that stuff out. So that's what I'm going to be doing. That's what we're going to be stepping this stuff up. This is going to be that dad coaching aspect, that legal coaching stuff, divorce coach, whatever you want to call it. That's how we're gonna go through this stuff. So, where to find the forms? So, state court websites. That's going to be the first place to go. Most of your state courts have some generic forms for that dissolution paperwork. They're going to have the summons paperwork and stuff like that. The clerks, they cannot give you legal advice. They can't tell you what to put on the forms. They can't tell you how to fill the forms out or what forms can or can't be filed per se, but they will absolutely tell you what has to be filed in order for the case to be opened. So again, that dissolution, they're going to give you the paperwork for that dissolution of marriage or to establish that parentage, and they're going to tell you how to issue that summons and how to fill out that affidavit and stuff like that. They're going to give you that kind of information. So that's how all that stuff is going to work, and that's going to be super important for you to ask some questions. Don't be afraid to ask questions of the clerk just because they can't answer it per se. They're going to tell you, hey, I can't answer that. You'd have to get a lawyer to answer that, and that just gives you an idea and the knowledge that, hey, the clerk can't answer that question. That's more specific, and that's something that I need to either go search out a lawyer for, or I need to hit up this live feed that Don's doing to be able to help me out and stuff like that. So we're going to be doing these lives all the time. We're going to be getting that information out, and we're going to be pumping this stuff up, right, dads? Dads supporting dads, dudes helping dudes. That's what this is all about. So, all right. So once you get all those forms filled out, once you get that dissolution, that petition for dissolution, and you get a summons filled out, and you've got your family law financial affidavit, you're going to want to get copies of that. You're going to want at least 3 copies of all of those forms. You're going to want to keep, obviously, a copy for yourself. You're going to need a copy for the packet that goes to your soon-to-be ex-spouse or your ex-girlfriend, the mother of your child. You're going to need a copy for that to send out to them, and you're going to need a copy to the court. A couple different ways that you can do this. You can bring it down to any courthouse in person and drop it off at the clerk's office. They'll tell you what office to go to, what desk to go to, and stuff like that. You can go in there and jump on that stuff, and they'll give you that information. You can absolutely mail it into the courthouse as well. Obviously, that's going to take more time for processing. You got to wait for the mail to go through, and then once it reaches the court's desk, then you got to wait for the clerk to file it through with all of the other paperwork that they're shuffling across and stuff. In person is going to get that docket usually opened right off because that clerk's going to be working with you right there on the spot to get that stuff filed. Or lots of jurisdictions nowadays have electronic filings, e-filing systems. That is a little bit more complicated. That requires setting yourself up for their e-filing system and getting your email services in there, and then figuring out how you go in there and get those documents uploaded. There's not a lot of help or self-help out there, and the clerks aren't real helpful in telling you how to use the system. They're very basic with that stuff. And how the whole process works. But if they do have the information, they will try to help you out, and they will get you that information as well. You're going to be filing in the clerk of the circuit court that you live in. So the county in which you live in, you're going to file with that clerk in the circuit court, and it's going to go to their family division, and they're going to be the ones that help you out, and they're going to be the ones that get you filed with that stuff. So that's what you want them to help you with. Now, fees. unless you qualify for a fee waiver, which means that I think you meet 120 or 150% of the federal poverty guidelines, you're going to be subject to a fee. Um, that fee ranges anywhere from like 150. This says $300 to $500. That would be accurate for a fully contested divorce. Some jurisdictions offer a lesser fee for those that have stipulations or divorce agreements. So the parties have sat down, and they've handled all this stuff out. Sorry about my dog gagging in the background there. They've hammered all this stuff out, and they've got all that stuff there. And some courts have a smaller fee because it's a lot less time for everybody to go through that stuff. So, but typical fees for a contested divorce are absolutely going to run you in this $300 to $500 range, and that's just the filing fee. That's just to get the case opened and started. That doesn't include the service of summons of everything on the other party. You usually have to pay usually from like $30 to $75 depending on mileage and stuff like that for for the law enforcement officer or the process server to go out there and serve that paperwork on somebody. Make sure you ask the clerk for their case number and copies of the stamped documents. They will oftentimes give you copies of the stamped documents so that you can show that the stuff was all filed and everything was taken care of. So, all right. So now we've filed everything with the clerk. Everything is getting going. We've gotten our divorce process started, and we need to get the other party served, either the spouse or our other parent in the situation. You absolutely have to legally notify the other person. That's through this process of service. This is either the law enforcement officer going out and meeting up with them personally and handing them the documents personally and getting their signature on a piece of paper, as well as getting that stuff back to the courthouse. It could be a process server that's licensed in your jurisdiction to be able to go out and also serve process on somebody. It is absolutely a big no-no to initiate a legal proceeding and go and try to serve these documents on another party yourself. So I've heard of other dads out there that have showed up at a custody exchange where they're taking the child for the weekend or for the day or whatever, and they've tried to personally hand these documents to the other parent, and the parent has refused, and they've come out and they've been like, what the heck? Can they actually refuse this stuff? The answer is yes, they can. No, it is not a legal valid way to process serve anybody for you to go up and do it yourself. You absolutely can initiate any sort of process like that. You certainly can initiate a family court process in that manner. So you're going to have to use a sheriff's office or a law enforcement office, or you're going to have to use a certified process server or a private process server that's authorized by your jurisdiction to do it. In some states, they do allow for certified mail for you to do it, but that doesn't happen very often, especially with the initial process. So you're just getting this stuff going, and they're first getting their documents on everything. Usually afterwards, if you're filing additional motions or you're filing additional documents, certified mail is a absolute way to be able to process serve a general motion or something like that after a case has already been opened. So the other way that you can do it, which is very, very rare because it's very, very rare that people are actually cooperating in these processes and willing to go through the process. But waiver of service would be if your spouse agrees to waive the service. So they waive the sheriff's office coming out, they waive that private process server coming out, and they sign a piece of paper and they say, yep, I've received it, I've got it, and I waive the service of process. That is another way to do it. But again, that doesn't generally happen because we don't actually get that kind of cooperation in this stuff. After everything is served, so if it's served by a sheriff's office, usually they have access to the court records and they file that stuff automatically back up with the court. If they don't, they're going to mail that packet back to you with their sheet filled out and their signature and the other party's signature on it, showing that they served process. Or they're going to mail it back to you and say they failed at serving the process because they couldn't find the other person, they couldn't make contact with them. So, but most of the time, the law enforcement offices, if it's done by law enforcement, they have access to the court docket and they just file the stuff directly into the court docket. Once that stuff is into the docket, then service has been completed, and we're going to get into waiting for a response here in just a second. That's the next thing that we're coming up to. If it's a private process server, they usually get that paperwork back to you either by US mail, or they bring it back to you, or you go pick it up in their office, and then you have to deliver that upon the court either by mail or in person to show the court again that process has been completed. And the first technical difficulty.